Good afternoon, and thank you for joining us for this Policy Committee meeting. I am Amelia Boyd, and I'm the Program Manager for the Medical Commission. This meeting is being recorded. The documents which will be discussed here today are available on the Policy Meetings page on our website, which is wmc.wa.gov. Christine Blake is the chair for the Policy Committee, and Dr. Pam Kohlmeyer is the presenter for these meetings. Once the presentation is finished, Ms. Blake will open the floor for committee and public discussion. Attendees, if you would like to ask a question or speak, please use the raise your hand function or the chat. Members of the public, when commenting, we request you avoid commenting on ongoing investigations or disciplinary cases, and to please make sure your comments pertain to the agenda items. Are there any questions about any of that? Does not look like it. With that, I will hand it over to Ms. Blake.
Good afternoon, and thank you for joining us today for the Policy Committee meeting. I know that we're going to post the agenda, I believe, Amelia, on just one moment, please. We have a few items to go over. One of them is the first one is the procedure for processing complaints against medical students, residents, and fellows. We had seen this originally and we deferred it. I'm going to turn it over to Dr. Kohlmeyer to go ahead and give her a presentation on this.
Thank you, Commissioner Blake. So this particular procedure ended up creating a lot of great discussion. We first talked about it a few months ago, and just to give some context, the way that the procedure was and is currently in place, it has a very protective stance in the sense that if there's, say, a fellow even that's done medical school, residency, they're in postgraduate training year number 7, there's a lot of protection to kind of protect them from having a record generated if they have complaints against them. And in some really good discussions with stakeholders, I talked to people in nursing, I talked to some people in pharmacy, blah, blah, blah. It seems like this is ripe for tweaking to kind of weigh that balance of protecting the public, which right now I think the public might be a little bit at risk. That's my own opinion. But so anyway, so if we're agreeable to this, I would recommend going not to the red line version, but the clean version that we could talk about that. I will say, right before the interested parties meeting on June 6th, I was looking at it like the 101st time, but I realized it didn't mention PA students at all. And I was like, how did we, I don't want to say forget the PAs, but why are there not PAs on here? And so we discussed adding the PAs. And so I did. And in some ways, that's very good. In some ways, when I went to look through like our authority to do so, like disciplining PA students, it's not clear to me that we have that authority like we do with the medical students. Like there is a clear statute that says that we do. With the PA students, it's very vague. So even though I presented this for you so that the PA students and the med students are treated the same, I would recommend that while we're all together, that we undo part of this, if Amelia is okay with doing this as a live edit, so that if it's a PA student complaint, that if we find out about it, we would send it back to their dean or their program director, because it's not clear to me that we have the authority to do anything. Does anyone want to make a comment about that? I will say too, oh yeah, Heather, go ahead.
Yeah, so Yes, so I think the PA section needs to be reworked. So PA students are exempt from licensure if they're practicing within their training program. And that's in your statute 1871-03010. So there is, if they are practicing medicine, they are exempt from licensure. This seems to allude that they can practice without a license, which I don't think is correct. So there's authority for the commission to write rules about practice for a student, but you haven't done so. So that's an area you can consider. But I do think the PA student, because they're exempt from licensure, you're right, that this, I don't know that I always say you need to, because it could be an unlicensed practice issue. It could be you want to refer those to the secretary if they're practicing outside their training program.
Perfect. So that's exactly what I was going to propose. So that if we find out about a complaint about a PA student, that we could send it back to the dean of the school. But if it is something that they are doing something that's beyond what they're allowed to do as a PA student, then it's then it is kind of an issue. But it's currently worded in a way that I need to fix. Yep. So it was done for the right reasons, but in looking closely at it, we need to get rid of a fair amount in the PA student section. Does anyone have an opinion about if you want to have the PA students addressed, period, in it? Because before it didn't at all, but it did seem a little bit like an oversight not to mention it. Dr. Domino.
Yeah, sorry, I raised my hand, but it's for the medical students. I mean, the residents, not about PA students.
Okay.
Anybody else have any comments about PAs
Commissioner
in this
Lopez.
document?
Yes, hi. I'd like to support the idea that PA students should be included. There should be some wording. It should be fairly explicit on how that is implemented so that it's very clear for all the reasons that were just discussed.
Beautiful. Dr. Domino.
This deals with the residents. Okay, look, I'm one of the few people on the commission that's spent over 40 years working as an attending in training programs. It includes here, the University of Pittsburgh as well. And I must say, with my residents, I don't know what the licensure is required here when they can get a license. But in Pennsylvania, where I'm trained, you could get it after a year. And we were told we should, because it meant that it was just something that was required. So I don't know how much these days this is required. A lot of these people, it may be a financial issue. They put it on the resident rather than on the department, whatever it is. But I'm very concerned about this because, in fact, even if they have a license, they may not be able to practice in their specialty, right? And so, and the fact is that as a faculty member, it is, when we've always dealt with this on the commission before this time, is that it's the responsibility of the attending physician to take responsibility for that if it's some kind of thing like a medical error or other things. I understand, I have no issue if it's substance use disorder or other, terrible type behaviors. But for in a training situation, these folks are under training. They are not trained to do what they are doing. I think it's just totally wrong, and I cannot support it. And I feel very, very strongly about it. And been on this commission for a number of years, we have never had this. And not only that, your whole redaction thing in this, it's just like, how do you even know it's a resident, right? You say, of course, it's the attending. It's like a first-year person doing surgery who had some complication. Well, it's the attending's fault. That's my opinion.
So when I presented this as a question to the FSMB attorney group, we were an outlier with this protection, not saying that it's wrong. And the only one that responded that they give any kind of difference to someone who's in their residency is if it's a standard of care issue. Like as our current policy is, they could have a felony conviction, they could have, multiple DUIs, there could be all kinds of stuff. And the way it was worded, they could be diverting morphine from the Pyxis.
No,
And
what I'm saying is that all those illegal and terrible behaviors, substance use disorders, psychiatric problems, those are very different. What I'm talking about is a quality of care issue. I don't use the word standard. Standards are very rare. Okay. So I disagree. I mean, it certainly is not my responsibility if a resident is taking some substances from a patient. That's the resident's issue. What is my responsibility is to ensure that my patient is dealt with well and safely, and that I am there enough to be able to supervise them. And if I'm not, that's my problem. It's not the resident's problem.
Dr. Domino, are you saying you're against this entire policy or some of the verbiage in it?
I'm against the policy here that I read that says once a resident obtains full physician and surgeon license, even if they are performing duties within their residency programming, not in a moonlighting setting, the commission is generally the appropriate entity to address complaints and take action if necessary. That's the section I have concern with, because if it's a right, you call it standard of care, it's really, there are very few standards. If it's a quality of care issue, that's the attending's responsibility and their lack of supervision and training.
Can I ask a question? So would it be different if they didn't apply for the full license? So when they apply
I
for
don't
a
care.
full,
You don't know why they're applying for a license. I mean, if they're out moonlighting, then maybe it's an issue because they're doing things themselves. I know I did moonlighting when I was a fellow. That was my responsibility. But in someone in a training program who they, a lot of them get licenses and they're encouraged to do so. So I'm talking about providing care in the residency program.
With your many years of expertise in this, how are concerns handled when when they're in their program and there are concerns with residents?
Residents
Might be
get
quality
reviewed
of care.
in our program. They get reviewed every day. They get reviewed on a monthly basis and quarterly basis and yearly basis. Some residents are discontinued due to lack of ability to do, like in my specialty, lack of ability to be able to do the job. Maybe they're better suited for primary care. So there's an intense, every ACGME approved program has all these requirements and that. And the fact is that, I mean, I have mentioned before, I've had issues where I've been supervising residents, medically directing. It's not supervising, medically directed residents, and things are busy. And then someone puts an IV in the patient and it infiltrates, and then they don't recognize that it's an infiltration. Well, that's my problem. I mean, yes, the resident contributed. Hopefully they learned, but they were training. Everyone makes mistakes in early training and even late training, right? If they've never seen things. And it's really the attending's responsibility. I think that the idea is very different these days. These trainees have a lot more, less independence, more oversight continually. Our residents have daily evaluations for all the ACGME requirements. And it is, I think you're putting a lot on a trainee who may become a very good specialist in their area. So that bothers me. And that will never go away from them.
do you think it would matter if we educated residents that, you kind of like making an informed choice. Like if you apply for full licensure, this is a downside.
People are so busy, they won't even know what to do, right? I mean, number one. Number two, I don't know why people apply. I know when I was a resident, I was told I had to. That was in Pennsylvania many years ago. I don't know enough about that. Did you get feedback from this from the University of Washington? I mean, really.
The feedback that we got, Hillary's on the line, she could probably speak, but they mentioned adding the employer being notified as well and the graduate medical education office if there was a complaint against a student, but it wasn't what you were saying.
A resident, yeah.
Mm-hmm. Hillary.
So thank you for the opportunity to comment. I did get that feedback that you relayed from UW, and also just wanted to thank you for the opportunity to collaborate on this. If there's going to be another opportunity to look at this and discuss, I can reach out with these concerns and I guess see if they have any further feedback regarding residency and PAs.
Well, I would suggest we really need it. And let me just say historically from the commission, and for the whatever 5 years or whatever I've been on it, we've dealt with complaints where it comes out that there is a resident involved. But generally, if they're in the training program and they're not moonlighting, and they're doing something as part of the training program, and there is a supervising attending, we've gone out, have tried to deal with the attending rather than the resident. Because the resident is a trainee. They're very similar to a student.
Okay, that makes sense. Thank you.
Dr. Lyle?
I just want to make sure the clarification or the distinction you're making, Dr. Domino, is whether or not they have a license during residency is whether they're within their training program doing training versus moonlighting outside. So when they're underneath the umbrella of their training program, they're being supervised, and the supervisory or medical management person is responsible. And then if they have a license, they're usually 2 years out or more, and sometimes moonlighting. That's a different scenario. And I think if the policy reflected that, would that be, is that the distinction you're looking for?
Yes, that's correct. That's what I saw before when we discussed this a while back, and then it was changed. Yes. Because some programs are 6 years. Okay.
Right.
Some of them, and these days, like you're a surgery resident, you may not even get a lot of experience until later on in your residency. I mean, it's just, and they're going to get complaints over their surgical care. It's not appropriate.
Right. I guess with the exception being the egregious things you outlined.
Right. Those things are different. Sure. Those are personal issues. And they need to be addressed. When I'm talking about is a quality of care complaint.
So something that might work.
I agree.
So what if we put this on hold until the next policy meeting, but I will tonight change the PA part like we talked about so that it goes back to the dean or the programs, and I'll put a little footnote saying that we don't really have the authority to discipline them with our current rules. And with the standard of care, I'll make a draft that says that if they're within their training program, like practicing within the program, that it should be sent back to the program director, to the GME office, like the UW people said, and maybe their facility as well, that they typically would deal with it. However, if it's a diversion issue, criminal conviction, those things listed in the current draft, those the commission typically would handle. Is that something that we would all support?
That's fine. I do suggest you figure out who things at some big programs that have lots of residents like the university, who it goes to beyond the GME office. Each department has program directors, for instance, so it depends on their program. If it's a fellow and they're in their fellowship doing things, so that we've had complaints about those folks, they're still in their training period, it may need to go to their fellowship program director. If it's something related to care in their fellowship. Okay, so if you're an internist and you're learning how to be a cardiologist, and there's some problem that's cardiology thing and you're a cardiology fellow, it 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 should go to the attending. The attending should have the complaint against the attending, if it's one of these quality of care issues, and it might need to go to the fellowship director. So I suggest you work with the UW in particular, that has a lot of programs. It's not just like small residency programs and large number of fellowship programs, to figure out the best language for that.
With the fellowships, that one's going to be a little bit tough too, because if it is like a procedural thing, that makes sense. Like they haven't done a cath before, that's fine. But like if it's that things that any other doctor would normally know how to do, it might not be involving the commission for standard of care things that they should have learned 4 years ago.
Yeah, I don't know. That's subjective. The ones I've seen have been more of in their procedural area, where they lack the training, not standard things like how to take a history and physical, right? Those don't lead to complaints. It's bad outcomes.
Any other thoughts about the fellows? Well, the good news is it looks like we get one more cycle to explore this very, very hot topic that is so easily debated. And there is no perfect solution to this. Absolutely. There's definitely not.
And there might be, Dr. Kohlmeyer, one person that it would be directed to, and let them at their level give it to whomever else they feel is necessary to see that, the program director, this person, or that person, and leave it up to that, instead of having to write all those titles in here, and then this one should tell this one, or tell this one, or tell this one. It is, so that it's not so in the weeds, I guess, is what I'm thinking.
Yeah, I agree. It's very complicated. But you do need to get the name of the attending physician.
Right.
Yeah.
So just as a final comment, even though it seems like we belabored this for a lot of months, it's a good thing. We have added PAs to this, which was a complete oversight for a while, I think. And we're trying to fine tune to find that balance that we can all sleep at night. So I think that this is good.
Thanks everybody. Thanks, Dr. Kohlmeyer, for all that work on this. That was a lot. Our next item on the agenda is the proposed policy for Commissioner and Pro Tem recusal to address conflicts of interest. And I will turn it back over to Dr. Kohlmeyer to present.
Yes. So the rest of the agenda is not as controversial, even though we have 2 brand new policies that we're talking about. So this recusal policy was something that our executive director Kyle talked about in the fall, and the commissioners were receptive to moving forward with this type of a policy. And it's important for many reasons. Part of it is so that the public recognizes that we really do try to have fundamental fairness in all that we do. And it is tricky to find that right balance of when we should recuse or we must recuse. And so this is a draft for discussion. I will say that it's met with positive feedback. If there's anything in particular you would like to address, we certainly can. I will say there was a good discussion at the interested parties meeting. Dr. Domino, do you want to speak first?
Oh, well, you wanted something like in CMT, you know, everything's blinded. So we have no idea where the facility is that's blinded. We don't know the healthcare system. We don't even know a counsel. It's just a complaint. We don't know, an expert witness. We don't know a past attorney. We don't know anything. I mean, it's blinded. So I don't know why that's here. I wonder if you could explain if maybe I'm misunderstanding over what I see.
Maybe just to finish taking a look at the policy. Heather?
Oh, thank you. So just a couple of comments. First, I think it's important to differentiate an actual conflict of interest versus an appearance of fairness issue. Because those conflicts of interest are going to be sort of your mandatory, you must. There's going to be other situations, and you've addressed some of them in your table and throughout, that are more appearance of fairness. Like we're just looking at, like, you know, just the fact that you know someone or you work in the same hospital system isn't a conflict of interest, but it may be an appearance of fairness issue. And I think we need to be careful that we don't bind recusal in certain issues or certain situations where you maybe don't want to. I think with using the word should in the table, I think you're going to find respondents counsel expecting recusal in a lot, and demanding it in a lot more cases than maybe is necessary. I think maybe changing where it says should in that table is like should consult the executive director, because I think that's the appropriate place to have that discussion. So, you know, if you work in the same facility where the complaint occurred, yeah, I don't think it's that you should. I think you need to have that discussion with Kyle, and maybe Kyle loops me in if it's a tricky situation. But I'm worried about having the word should for all of those. I think that's, yeah, those are my main points. We're just to make sure we're differentiating between an actual conflict and then an appearance issue.
And just really quickly, while you're on the line, were there any of the musts that you thought were too strong?
No, I thought those were mostly appropriate because they were really they weren't all conflicts, but they were appearance issues that I think that were a good, you know, you don't want to, if you know you work with the expert and they're in your practice, that's you need to recuse. But you know, some of those where you work in the same healthcare system, those are really going to depend on the facts of that case and your, you know, how closely you have a relationship, if any.
Okay. Kyle?
Thanks for the feedback, Heather. I'd be fine with changing the shoulds to be something like should consult the ED. And Dr. Domino, you know, and part of this conversation, and I'm heartened by the fact that there are some folks from outside the immediate circle of the commission on this, is I don't think it's very well understood just how redacted and how de-identified the vast majority of material is that you folks deal with. Really only, I mean, I can't imagine many situations where anyone other than the reviewing commission member knows the identity of the individual or knows the identity of the healthcare system, et cetera. But Heather made a very fine point, and I just want to reiterate it for the benefit of everybody here. You know, a genuine conflict of interest, as she mentioned, is mandatory. And that's usually under our State Ethics Act. You're usually almost always dealing with a financial interest. So you would have a financial interest in some sort of underlying policy. With regard to these, though, we get into a little bit more of a gray zone. And when I've talked to commission members about this in the past, what they really want is some sort of touchstone where, you know, they can look at the situation, because it doesn't come up very often. Although there was one today, actually, or maybe it was yesterday, where a reviewing commission member contacted us to say, you know, now that I see who the complaint is against, because I hadn't seen that when it was going through CMT, I know this individual and I cannot serve as the reviewing commission member. And so, Karen, to your point, I just don't think that the vast majority of people understand all of the de-identification and redaction that goes into the primary material that you folks deal with at CMT, certainly in the disposition panel. The one place that I think it's the most important, and Heather, feel free to disagree with me, is with regard to hearing panels, because that is the that's the last stop on the train. In terms of the commission making a decision about the status of somebody's license. So again, I think that this is very important. This is a somewhat, this is an effort at transparency on the commission's part. I strongly encourage you folks to look through it. As you're aware, Pam and I worked on this kind of in concert. I did some of the original drafting on it in the days of yore. And again, I think it's really important for the commission to think about these issues. We can always try and educate the public about how little you actually know specific to the identity of the individuals. But this is really meant to be an outward-facing policy, and encouraging transparency on the commission's part.
So I just still don't understand about CMT. I mean, maybe if you're in some small group or something, you might know, but I think it's impossible to know where it's coming from.
We've had a couple that have come through over the years where somebody immediately is like, I know what's going on here. Actually, Miss Blake had an instance where she clearly knew who the person was without even knowing the name or the system, because it was at kind of an affiliated hospital. Yeah. Chris, I'm sorry if I'm not remembering the exact fact scenario, but I remember talking to you about it and you instantly being like, I can't touch this. I know everybody involved.
So maybe just somehow emphasize that, I mean, because I hate to even do CMT if I violate this policy and I have no idea when this person is from. I don't know the person. I don't know anything about it. Can you just say that most of these are redacted and the people involved in CMT have no idea about it?
Again, I think Pam, I don't know if you had mentioned that in an earlier draft, and I don't have. I'm having technical issues with Teams yet again, so I don't know if that's specifically highlighted. But to that end, you know, Dr. Domino, when we're doing this, if we're ever, this is again meant for outward transparency, but if for some reason, pardon me, you know, opposing counsel or respondent or somebody down the road raises that, we keep a copy of every CMT packet, and a redacted copy. So we can simply say, listen, you know, Dr. So-and-so had no idea who this was. But again, I'm significantly less concerned about CMT. I am very much more concerned about RCM duties and hearing panel duties, because those are instances where there is some peeling back of the redaction layers.
That was going to be my question, Kyle. Isn't this more for as the RCM on the hearing panel? Sometimes when it comes through CMT, and I think I may have, I don't know if it was there, but I know I noticed one where I thought, I know this story, I'm going to recuse myself. Maybe I'm thinking of somebody else, but I'm going to recuse myself.
Honestly, Chris, that's the best way to handle that. And Pam has a very nice note at the end that the purpose of this policy is to encourage recusal. We have 21 regularly appointed commission members plus a bank of pro tems. It is not so we have redundancy built into our system. We have other people who can handle, complaints, et cetera. So again, from the standpoint of transparency, again, this is meant to encourage folks to understand the issues, and also encourage commission members to step aside. And again, please, you always feel free to call me and ask, hey, when in doubt. But I'm going to tell you again, when in doubt, just go ahead and recuse yourself. Let staff know.
And I think it was on the first page that it mentions about how there are redactions. So sometimes we don't necessarily know. But Dr. Domino, if it would help, I could put another asterisk by
Yeah, I
CMT
put a footnote under
on the
CMT that
table. Yeah.
most these are redacted and commissioners don't know the details, although whatever they may recognize it or whatever. I mean, I don't know, whatever you want to say, I think would be helpful, because that was my only issue with it, because I could just see getting into trouble, and I have no idea. I work in a huge healthcare system.
Yep. No, I'd be happy to do that.
99% of the people I don't know.
Same with me, Dr. Domino. It's a huge healthcare system. And while, as was mentioned, I may be involved in that healthcare system, I may not know anything about the provider in Oregon or know of him or have worked with him. So, and I don't, correct me if I'm wrong, Kyle, but if that is the case, then it's not an issue.
That's correct. And again, Heather made the point, just again, for the benefit of the commission members, that what we're dealing with here is an attempt under a somewhat gray judicial doctrine called appearance of fairness. We have periodically had concerns raised by outside parties, whether it's opposing counsel, whether it's a respondent, that occasionally happens as well. Sometimes that, they feel like there's no way that, so-and-so could be completely unbiased because they know, the respondent, or they know the patient, or they're familiar with the patient care. Again, I don't think the vast majority of people really understand, certainly at the CMT level, certainly at the disposition panel level, just how redacted the material is that you have to work with, or that you're hearing from your fellow commission members. So Pam, I like Dr. Domino's suggestion, if you don't mind putting another asterisk in there, just as a footnote reminder that, again, we really take extreme efforts to kind of address this.
You might do it under disposition panel as well, because we might not know anything about it, even though we're in the same institution or system.
Amelia?
I was just going to mention that this is an outward-facing document, but we don't address what CMT is in this document. So, like, a layperson wouldn't have any idea. That means nothing to them. So it might be good if we put in a little paragraph in here that explains what CMT is and what CMT stands for. It's not country music television. So it might be good to stick that in here so that, someone reading it on our website will know what it is. And then you could explain how redacted those documents are that go to that meeting.
Good point. I don't remember. I don't remember if we spelled out RCM or not, but if you didn't spell that out, I could do that too. Yep.
Yeah, we didn't.
Good, good ideas. I'll add that.
Yeah. Mr. Lopez?
Yeah, hi, thank you. And while I understand to some degree why we are trying to put together a policy for something that is, in my estimation, and I think in the estimation of probably many people, and to the point we just went through now, which is the discussion that we had, it is such a gray place to be. It's difficult for me to understand the process of trying to put something in a box that's so difficult to define. And I will use the example that it is so difficult to define that even the Supreme Court is having a tough time with defining recusal. So while I don't disagree, I do believe that having an awareness of the principles, I think, of what recusal is, I think is more important than trying to put every little thing in a box and put all the marbles together where they need to fit. And I understand why we're doing it, and I understand the spirit, but it's just difficult for me to just sort of do the check boxes and go through the algorithm. My sense is when from a moral and ethical standpoint, if I know someone that's either the patient and or the respondent, and I've had some degree of dealing and or something that certainly is recognizable, and it is unclear to me, my first step is to speak with the executive director and say, I'm torn on this one. What do you advise? I always try to go with the saying that in a multitude of counselors, there's safety. So if I don't know and if I'm unclear, well, maybe I should just go talk to somebody about it. Thank you.
Thanks, Dr. Thank you, Mr. Lopez. I think Kyle's next.
I just wanted to follow up ever so briefly on what Ed's comments were talking about. I understand where you're coming from, and it makes sense. Again, part of the exercise of doing this, and again, if the commission does not want to adopt this kind of approach, we could certainly go back to more a principles-based approach. But it is meant to be outward facing, to let respondents, opposing counsel, other interested parties kind of know how the commission approaches this. And, again, if we decide that going to this level of detail isn't necessary, I'm fine with that. But again, there needs to be, and I think the commission, when I talk to you all kind of informally about this, I do think that there needs to be some sort of central touchstone where all the commission members are kind of directed. Many, many years ago, that was always Dr. High's role, was to kind of cultivate and understand where potential conflicts of interest may arise or where appearance of fairness issues may arise. But again, I think it's meant to be outward facing, Ed, as with obviously the commission members all agreeing that these are kind of the standards that you all think are important. So we can go to a more principles-based approach and get rid of the grid. I'm open to that by all means. But again, I'm following up on a series of conversations I've had with you that you all want to do something. So again, the approach can be certainly revised.
Dr. Domino. Oh, sorry.
I just want to follow up and say that just to be clear, I'm not opposed to policy. I just want to be clear-headed about why and how we do it. That's all.
Kyle, what I think one of the things is, I think all these things are important, but I'd rather see it in a paragraph under each of the sections, defining what the CMT means, defining what RCM means, with, I don't even mind numbers or something there, or must or this or that, whatever your language is. I find it hard to look at the table and figure it out. And I wonder if it might be more problematic, as opposed to saying this in a paragraph form under each of these things. With a statement, you can say disposition panel. No one knows who that is other than a few people, right? So anyway, that's just my feeling about it. I worry this grid may be unhelpful and may create more problems. I certainly, Kyle, it would create more problems to you or anyone in your position as well.
No, I appreciate that sentiment, Dr. Domino. Again, the process of kind of coming to this is a little bit novel. Most of our colleagues don't do, meaning within the DOH umbrella, don't do anything remotely like this. Everybody's obligated and mandated to follow the actual conflicts of interest rules. This issue regarding appearance of fairness, though, is something that it comes up with periodically, and again, to go back to the mantra of kind of transparency, I'm fine. I mean, it sounds like maybe there's a desire here to table it or actually look at an alternative to the particular this particular table and do it in more kind of narrative form. I'm fine doing that. We can come back to you folks and talk to you in 3 months. But I do feel very strongly that it's important that we address this in some way. That's partly my experience with the department. That's partly my experience as a line attorney and then supervising staff attorney with you folks, because again, I don't think that the standards or the potential issues are particularly well understood. Definitely on the outside of the commission, and on the inside of the commission, it kind of comes up randomly. Like I said, there was one that just came through the other day where somebody who was assigned as an RCM raised their hand and said, "I can't do this. I know this individual." That's a very, it was very forthright. It was very easy. Okay, we'll take it off. We'll add a notation in Eilers that you're screened from the case, meaning we're not going to contact you for a hearing panel down the road, even though you're not RCM. And so, again, I'm happy to do that. I'm happy to take it back and kind of talk
Should
about
we
general
talk
principles.
to the whole group, like in the business meeting, to get other feedback about it? I mean, do you think, rather than just a small group?
I'm fine doing it whichever way you want to. We do have, I actually don't think that the July business meeting is going to be terribly busy. So
hopefully
if
no
that's
workshops above and or whatever they are before and after.
I don't think we have any rules hearings this time.
Yeah, whatever hearings. Yeah.
So we could certainly do that. But again, the role of the policy committee on something like this is to kind of refine their approach. And so if we do that, I would hope that you folks can verbalize to the other members of the commission what your concerns are or what you think works and what you think doesn't. I don't want to represent, I don't want to try and represent 17 different points of view.
Yeah, I would personally, Dr. Nomino, feel a little uncomfortable presenting this as the chair for right now for discussion there before maybe we took another look at a draft and hear what other people right now on this in this meeting might want to add to how they feel about how this document reads.
Can I ask one thing? Do you think it would be helpful if there was a paragraph that talked about what CMT is, what RCMs are, talking again about sometimes with redactions, it's very difficult to recognize who people are or where people are. But once someone finds out, these are examples that typically would be when someone must recuse. And then you have just the musts altogether. And then these are situations where they should consult with the executive director. Do you think that would be helpful? So it's not bouncing around between must and should, or not?
I don't want to monopolize, but I actually like that idea.
Well, you are the chair of the commission, so that's a good thing. We aim to please.
Anybody else have any comments to add to that? Amelia, do we have anybody from the outside on this call, in this meeting?
We do, but there's no hands raised or
okay.
The chat.
So is the consensus to defer it, put that together as you just mentioned, musts and shoulds, and bring it back?
Yep.
Okay. Well, that was one of your non-controversial ones I talked about.
Well, I missed that one.
Okay, and let's see, back to the agenda. Okay,
AI.
proposed policy AI. Dr. Kohlmeyer, it's all yours.
All right. Well, I'm going to go out on a limb and say that this isn't very controversial, I don't think. We had some great feedback. First, the mastermind behind wanting to have a policy about this was Micah. It is something that FSMB just came out with a guidance document this spring. We would be cutting edge as far as state commissions taking on this on a policy level. FSMB had their main attorney that leads these. It's like all of the different boards have a few attorneys, and we're invited to this once a month meeting. And he came to our interested parties meeting, Frank Myers, and he said he loves the policy. Very glad that we used FSMB's stuff in it. And he just yesterday gave me some new feedback. So if we go with live edits, it's not a lot of them, but they're all good. So the first minor one, that this is just something I picked up myself. I was reading something by the AMA just a couple days ago, and there's some discussion about AI. We all think about artificial intelligence, about augmented intelligence, which is one of the terms that I use in the intro, but I'd like to see it in the title too, I think. So it's artificial, assistive, augmented, because all three of those are used with AI. So if no one's opposed to that, I think it would be a good thing, since the AMA seems to be happy with that. And then going down to within the policy statement itself. Okay, so that sentence right at the end of it where it says, however, before we go 1, 2, 3, the last sentence before the subheadings, if we change the wording just slightly, I can't, there we go. Prior to the use of AI involving a patient's care, the practitioner should understand the following. Okay, mutual consent, that's all great. Go down to number 2. He recommended striking the last sentence in that basically, because he said we wouldn't want like family practice docs or people that are not specialists to feel like when they're using AI that somehow they're doing something wrong if it's a question about a mole or something, which isn't in their it is in their scope of practice kind of, but it just, he thought it would be better if we don't be quite that specific. And then he also said too, rather than calling it autonomy of the practitioner, if it was focused more on the scope of practice. So if you change the italicized autonomy of the practitioner to scope of practice and the standard of care, I think that would be better. Okay. And then for number 3, that third one, just strike the word understanding in the italics. Okay. Now, he also said he would recommend, and I don't want to waste your time, it seems like editing stuff, which it is, just moving the policy statement section after the part that talks about the federal and state, the FSMB stuff. Yeah. So putting this whole section in front of the actual policy statement. He said he thought it would flow better, which he's right. I just did it so that we were kind of like not hiding the ball where you had to read it more to get to the actual policy statement. But he's right, it does flow better this way.
So I will fix that when we're not.
Beautiful. All right. Okay. And then he recommended in the conclusion adding one sentence just to really reinforce the point. There we go. Okay. Even though it's already kind of said in that paragraph, to add a sentence that says, irresponsible use of AI can raise the risk of patient harm and lead to potential disciplinary action by the commission for deviations from the standard of care. What a beautiful statement, and so true.
Do you want that at the very end of this
Yep.
paragraph?
Yep.
Okay.
The very last sentence that everyone walks away and goes home with. Yep. Mm-hmm. Although we're not done. If you're doing that from memory, that's amazing, but you might be doing the email that I sent you to give you a heads up.
I was going to say the same thing. If she's just doing that from you saying that, that's.
Of course I am.
Yes. So with that, are we happy with the wording of the thing, just knowing that a couple of things might shift so it all flows nice, but the actual wording we're all happy with? Knowing that AI is very cutting edge, whether it's augmented, artificial, whatever. But at this moment, from what we know, this is to try to give some guidance to doctors and PAs without them feeling like, oh my gosh, I can't do this. It's too complicated. It's trying to make it easier for them to understand what their responsibilities are. Dr. Domino?
Well, first of all, thanks for the excellent document. I agree with the changes. The one question I had deals with the issue of the policy of mutual informed consent. For instance, in my area, a lot of academic institutions are using AI to predict who might do poorly after surgery, and they might be prearranged to go to surgical ICU rather than the floor based on comorbidities. Is that really something that needs to be said? I mean, I don't know, I know Swedish uses a lot. They use a device which I've been using experimentally, and people have informed consent in a huge consent form, but they consider it standard of care, and basically analyzes an arterial waveform, uses some AI stuff in it, and comes out with recommendations for whether to give more fluids, whether to give an inotrope, or whether to give a vasopressor. And I don't even know if they realize there's AI in there. So I know you say when possible. I think that might cover it, but I was just curious about those things because I'm not sure a lot of doctors know when AI is being used or not.
Yeah, I think that you're exactly spot on. Like at first, when Micah and I had this discussion, I don't want to put words in his mouth, but I heard him say it should say must, that they must get consent. And I thought, okay, back in the day, I'm dating myself, but like we used the EKG machines and it would have that automatic read that may or may not be true, but you'd look at it and it might influence what you think or not think. No one ever got consent for that, ever, right? It was just a tool that the doctors could look at or not look at or whatever. And so must is definitely, I think, not an okay word to use. Should, when reasonably, whatever, it softens it. But if it could be softened even more, I mean, I think I shouldn't predict, but I think as AI progresses, it's going to become this normal tool that is used in so many things that you don't even recognize. So we don't want to box providers in so that they're going to be not compliant when they have no idea it's happening, right? Yeah. And there's only so many things you can talk about with patients too. You have a 15-minute appointment. If you go through every single consent with the AI, that could take you 45 minutes. So I don't know. Any thoughts about if you want the language tweaked a little more or less is more, like taking some of it out? I don't know.
Mr. Lopez?
That last sentence, if we could go back to it, please, where it starts with irresponsible.
Mm-hmm.
So the moment I read that, I frankly became concerned because it's such a subjective term to think of in the event of a violation of rule or law by a respondent. I would think that the respondent would say, well, how do you know it was irresponsible? What's the definition of irresponsible? What makes it irresponsible? Particularly when you're talking about cutting edge technology, much of when the development of technology is going on, one person's irresponsible is another person's going forward with the process. So when I saw the word irresponsible, I'm going, boy, I'll tell you, that could be a can of worms.
Yeah, I thank you for mentioning that. I was wondering about that. How are we going to define irresponsible use?
Does inappropriate help at all, or is that still too?
I like that better.
Okay. Well, if you like it better, I like it better.
Even
too.
appropriate use of AI can cause problems, right? You don't know. And so that's part of the whole thing. So I'm wondering about use of AI can raise risk of patient harm. I mean, it's not necessarily inappropriate. Most doctors don't understand what's in the algorithm. Yeah.
That's
I like
true.
that. Yeah, true.
So I'd strike that, just put use of AI.
Just put use.
I think at this point in time, really.
Yeah.
Yeah.
Maybe change the word can to may, just to make the lawyers on the line happy.
May. Yeah.
Yeah. Good idea.
That's beautiful. I like that.
I was just thinking
Go
of
ahead,
this
Dr.
section
Gilbert.
before that I was talking about informed consent. Well, maybe the physician has no idea what's used, right? So doesn't that really, I mean, if the provider knows, then maybe when reasonably possible, then they should provide consent. But many of us won't even know, right? We don't know what's used. So we shouldn't be held responsible for something.
I was going to say, do you want to
consent?
Yeah. Did you want to box yourself into that? I don't know. As a provider.
I mean, I'm not sure people have a lot of ability. Provider has a lot of decision-making aspect of this. It's often healthcare systems that institute these things.
Yeah.
And we just follow the rules.
Yeah.
Do you think it should be worded more softly, that oftentimes the use of AI should include a discussion between the provider or the practitioner and the patient so that they're aware of its use, or something like that?
Yeah,
something
if known.
Yeah.
Use, right?
If known, yeah.
Yeah.
Okay. No, I can trim that down, because I definitely hear what you're saying. And I really think, I mean, this is going to, if we pass it, it's going to go up for a 4-year review, and people, I'm estimating in 4 years, are going to be like, oh my God, why did we think that everyone had to consent to like all this stuff? This is just normal. It's like using a stethoscope. Do I have to get consent to use a stethoscope? I mean, no. I mean, like, yeah.
Anyway. I always ask my patients if it's okay if I can listen to their heart and lungs.
Well, yeah, but if you're listening in the back, it's not quite as significant as like listening in the front where there are body parts. But yeah, anyway, okay. Okay, so we'll change the wording of that to be more broad. Unless, what's the word I'm looking for? Mandatory. Beautiful.
Any other comments from the group? Sorry.
Oh, so thank you. Nothing substantive, but we just appreciate the WMC has worked on this policy, and we have a lot of physicians very interested in it in our AI work group, who I'm sure would welcome any opportunity to collaborate in the future. So thank you.
Thank you.
Since it has to be revised, Pam, couldn't you send it to them for their input?
Yeah.
Right. We can't. Yeah. Because we can't bring this up, right? It has to be approved by us. or not?
With
I
the
don't.
slight revision, if it gets sent out ahead of time to you,
Mhm.
we can bring it to
Yep.
the meeting.
So this is a new policy, so you can definitely bring it to the
Yeah.
meeting, even with revisions, a ton of revisions between now and business meeting, as long as it's
So
in the
maybe we
packet.
could get their input before the business meeting.
Yeah. And
Yeah.
they were at the interested parties. And so they've already kind of had a chance to review it. But with that change, they'll get another chance. So good idea.
And this is also a policy that has to go to secretary review, so that'll add time in there too for additional comments.
So Heather, is that before or after the board? Are we at the board level look at it?
So after the full commission looks at it, if they approve it to go forward, it'll go for secretary review. Then the secretary's office will send back comments. It usually takes a couple months or for your next meeting, usually with any comments they might have. You don't have to accept the comments or incorporate the comments, but they're there for your consideration. But at the same time, you could look at any edits that other parties might have.
Okay, thank you. Any more comments on this one before we move ahead with the agenda? I think we're at time, but so telemedicine policy
Yes.
is next on the agenda. Dr.
So
Kohlmeyer.
this one is non-controversial. There is a statute now that supersedes our policy. So we're recommending it is rescinded. Yeah. How's that?
Good. Any comments?
Yeah, no, I agree. I just had this policy statement. Is that the old policy since it's 2021 and now? Okay.
Yep. Literally, the statute just took effect on June 6th. And so it is hot off the press. It's a uniform telehealth act. And we were like the first state to pass one. And so now it supersedes this policy. And of note, the very last like paragraph in this policy talked about AI. So what we knew about AI at that moment was this much. And it was good that we talked about it, but now we have a whole policy on AI. So there's
So
progress.
people will still see from if they go on the commission website and see the law, whatever it is now, right? The policy adopted by DOH.
Well, the statute was passed by the legislature.
Yeah.
And so
okay.
now this is going bye-bye because the statute is what's the law.
Okay, what I was wondering if physician would have access to the statute.
We could put it on the website if we want. Amelia, what do you think about that?
So I think once you rescind this, like if you approve it for rescission at the next business meeting, then we'll put a notice in the newsletter and probably the commission connection. And then we can, I mean, I can talk to Jimmy about putting something on the website to refer them to the new statute.
Yeah, I think it would be good just because it's something
Yeah.
that's is a
normally
repetitive
what
issue
happens.
we see and people don't know.
What was
Yeah,
that?
once it's officially rescinded by the commission, then we take it off the website. It can't be found, and then we supplement what was there with a link to the statute.
Thanks, Jimmy. Everybody agree? Thank you. Okay, next on our agenda. Yes.
Whew.
Sorry,
All
I
right.
can't look at two screens, so I have to go with what's Amelia's showing. I don't have two screens on this laptop.
No, it's good.
So-
It's the proposed policy. I can read it. Clinical
Okay.
experience assessment. So I will tell you, I felt like an investigator trying to track this down. Apparently, this clinical experience assessment tool was passed by the IMG work group, and it was sent for secretary review. and somehow it was in the ether space. And so, what we have done is we have brought that back. It did get some comments from the secretary's office, minor wording changes that have been implemented into this. And the front page is just to explain what the tool is and how it's designed to be used. And so there was some discussion, should it be a policy or a procedure? And Micah thought that a policy would be good because there's a little more power with policies. And because there was like an IMG work group, this kind of elevates it to some extent than just being one of our procedures of how we do things. And so if there's any input or feedback, we're open to it. The initial kind of wording Micah had drafted, I don't know, I'll say a year and a half ago, but I'm not sure exactly when. And then I just did some very minor tweaks to it to make it easier to read. Any questions on it? It's to try to help IMGs have some clinical experience so that they can improve their skills and be more likely to get chosen for a residency. It's not something they have to do, but it's a way to help that pipeline of getting them up to speed or more desirable to a program to say, yes, we're confident that they're ready. And so it's to help create a pathway for them to get into a residency here. So it's a great idea. It wasn't my idea. I just found it. So yeah.
So I was just going to say, I thought it looked good. One thing that if you're looking at ACGME requirements that we have to evaluate on a daily basis are communication skills. I think there were some in here, but they include like the individual treated me with respect and treated patients with respect. You know, they are that communication is one of the big issues with people coming from outside the U.S. and having been at the meeting last week in D.C., that ends up being an issue because physician, PA, whatever, these are physicians, I guess, for practice here is a lot more collaborative and team oriented, and communication is really important. Whereas in a lot of countries, it's doctor knows best. And then they don't really understand the cultural aspects in the US. And I think that's important in them. Is that covered here? I mean, a lot of these just seem to be like basic medical tasks. There's collaboration as a member of a team.
Pam, if I may, I could speak to it a little bit in the work group.
Great.
Or Dr. Domino. In the absence of Micah, the IMG implementation work group is actually the creator of this. It was, I'm forgetting her name, but it was our representative from the UW. It is not mandatory. It's not required in the bill. However, the work group has really worked together to come and create something that they believe can be a tool for IMGs looking to get residency to help them prepare. So while this isn't mandatory, it is part of a report that we put forward to the governor. And it took a lot of work to get everyone to come on board to get a unanimous support for it. So while we might think that it could be tweaked here and there, really you voting on this holistically would be our best effort. Otherwise, it has to go back to the work group of more than 15 people and then get their buy-off on a change in the language. And it's been about a year in the works. So like I said, not mandatory part of the law, not mandatory for IMGs to use, just a helpful tool that the commission can vote on to move forward.
I mean, I'm happy to do that. I'm just saying that communication skills has been one of the big issues with IMGs. That because it's a different culture in many of the countries they've come from. But I'm happy to do this. I mean, they'll pick up a communication issue in a residency interview, as an example, or a job interview.
Yeah, thank you to both of you. If there's any tweaking to be done, it would be the page 1, because that's our page. The actual tool was from the IMG group. So did you want to have a sentence added about communication in that or not?
I don't think so. I'm just saying it came out last week as like one of the major issues, a communication, acculturation.
Awesome. I'm glad that we love it.
Yes, I think it's great. It's great work. Any other comments? So I blew right by what we wanted to have a vote on, which I apologize for. We just kind of rapid fire went from one policy to another. Was there, do we need to vote on some of these? Amelia, do we need to vote on? I know that the ones we're deferring.
So you're deferring the first two.
Mm-hmm.
Pam's going to update the AI one tonight.
Mm-hmm.
And then you'll move it forward and you'll recommend it for secretary review. The telemedicine policy you're recommending for recusal. I think if you want to vote on that one, you can, like on the AI one, you can say your motion would be to approve as will be amended. And then at the business meeting, you will recommend that one for secretary review. And then for those rescinding of the policy, you would vote whether you want to rescind it. You recommend rescission. And then this last one, you'll vote to recommend that they approve it for secretary review. So 3 and 5 are pretty similar.
We have a motion from someone on these as noted
So
by
moved.
Amelia.
Yeah.
Second.
All in favor? I can't see you, so any opposed, I guess I should say, too. Okay, any public comment or anyone that has a hand raised that I'm not seeing, Amelia?
Not that I see. But I just wanted to make a quick note that on future business meeting agendas, when we list out all of the items that you discussed at policy committee, I'm also going to put what your decision was at the policy committee meeting. That way, like, we won't run into what we ran into last time where we had to keep bringing back this medical student one. So you won't see the medical student one or the second proposed policy in the packet. And then there'll be a note on the agenda that says that one's being deferred for further work. And then 3 and 5 will say you're recommending approval to go through the secretary review process. And then 4 will say you're recommending rescinding it. So really, it'll be a little bit easier because you can just, Chris, you'll just be able to say, this is what happened at the meeting is what's in the agenda. And then if they want to discuss anything, then you can ask them if they want to discuss. And then,
okay.
Yeah.
Wonderful.
Yeah.
Thank you. Thank you, Dr. Kohlmeyer, for all that work on here. It's a lot.
Agree. Thanks for all the great work.
Yeah. If there's no further comments, then this meeting is adjourned. Thanks all.
Everyone.
Thank you.